you've got those contract law exams coming up, right?
Yeah.
And I know it can feel like, oh my gosh, a mountain of like legal jargon.
Yeah,
But
definitely.
what if we told you there was like a way to kind of break it down and make it click
Hmm.
and actually maybe even kind of enjoy the process?
Yeah.
That's what this deep dive is all about,
Yeah,
right?
exactly.
We've got this guide. It's like a cheat sheet
Hmm.
for understanding the essentials,
Okay.
and we're going to unpack it together. So we're talking about like everything from the basic building blocks of a contract
Hmm.
to those tricky scenarios that love to pop up on exams, right?
Yeah.
And we'll even throw in some real life examples to, bring it all home.
Perfect.
But before we get lost in the details, let's take a step back and look at the big picture.
Oh, okay.
What is contract law really, and why should you care?
Well, contract law, it's more than just dry rules and regulations,
Right.
It's the backbone of how we interact in a society that's built on, promises and agreements.
Okay, yeah.
So think about it. Every time you buy something
Hmm.
or sign up for a service or even shake hands on a deal, you're engaging
Right.
with the principles of contract law.
Okay, that makes sense. So it's not just like this abstract legal concept. It's literally like woven into our everyday lives.
Exactly.
But where do we even begin with something this massive?
Well, you're right. It can feel overwhelming.
Yeah.
But like any complex system, it all starts with a solid foundation.
Okay.
And in contract law, that foundation is the definition of a contract itself. So legally speaking, a contract is an agreement enforceable by law.
Hmm.
This means it's not just a casual promise, it's a commitment
Yeah.
that carries legal weight.
Okay.
And in India, this definition comes from Section 2 of the Indian Contract Act.
So if we don't meet those requirements, it's not really a contract,
Oops.
legally speaking.
Exactly. It might be a moral obligation or
Right.
a social expectation, but it won't hold up in a court of law.
So like, let's say I'm in a cafe and I order a latte.
Okay.
Is that technically a contract?
It is, yeah.
Really?
You're making an offer to buy the latte
Okay.
at the listed price, right?
Mm-hmm.
When the barista accepts your order and they start making it, that's acceptance.
Okay.
And then there's an exchange of value. You pay for the latte and they provide you with the delicious caffeinated goodness.
Right.
Boom. You got yourself a legally binding contract,
Wow.
all before you've even had your first sip.
Contract law in action right there at the coffee shop.
Exactly.
I love it. So this guide talks about these building blocks of a contract.
Yeah.
What are they exactly?
Well, think of them as the essential ingredients for a valid contract, right?
Okay.
Offer, acceptance, consideration, capacity to contract, consent, and a legal object.
Okay.
And if any of these ingredients are missing,
Yeah.
the whole contract could fall apart.
Okay, so it's like a checklist, right?
Yeah.
You need all the boxes ticked for it to be official.
Mm-hmm.
But let's break down a few of those building blocks.
Right.
Offer and acceptance seem pretty straightforward,
Right.
but I bet there are nuances we need to watch out for.
You're absolutely right. Take offer and acceptance, for example. It's not just about saying, hey, want to buy my car,
Right.
for it to be a legally valid offer.
Right. There's got to be more to it than that.
Exactly.
What makes an offer official in the eyes of the law?
Well, a valid offer has to be clear, definite,
Okay.
and leave no room for ambiguity. It needs to specify the essential terms,
Okay.
like the price, the item being sold,
Mhm.
and any other relevant conditions.
It's all in the details. The guide even suggests, like, actually diagramming
Yeah, that's a good idea.
the communication timeline, like mapping out, like, a text conversation gone wrong.
It's a fantastic way to visualize the process
Yeah.
and make sure that a genuine offer and acceptance took place. After all, timing and communication are key in contract law. And this is where those landmark cases come in,
Okay.
providing concrete examples of how courts have interpreted these concepts
Yeah.
in real-world situations.
Okay, case studies. Hit me with some legal drama. Which cases are essential for understanding offer and acceptance?
Well, two of the big ones are Carlil v. Carbolic Smokeball Co.
Okay.
and Laman Shukla v. Gary Dutt.
Okay.
They might sound intimidating,
Right.
but they actually involve pretty interesting scenarios.
Okay, let's start with Carlil v. Carbolic Smokeball Co. What happened there?
So this case is all about the power of advertising. Back in the 1890s,
Okay.
there was this company, Carbolic Smokeball, and they claimed their product could prevent influenza.
Okay.
And they were so confident,
Yeah.
they even put out an ad offering a reward to anyone who used their product and still got sick. Well, Mrs. Carlil used the smoke ball, got the flu, and sued for the reward.
So did she win?
She did, yeah. The court ruled that the company's advertisement wasn't just some, marketing fluff.
Right.
It constituted a valid offer to
Yeah.
the public, which Mrs. Carlisle accepted by fulfilling the conditions.
So companies can't just make wild promises in their ads without expecting to be held accountable.
Exactly.
That's a win for consumers.
Yes.
What about Lalman Shukla v. Gary Dutt?
Well, this one dives into the nitty-gritty of awareness and intention when accepting an offer, right?
Okay.
So the defendant sent his servant, Lalman Shukla, to find his missing nephew.
Mm-hmm.
Later, he announced a reward for anyone who found the nephew.
Okay.
Lalman, unaware of the reward, found the nephew.
Oh.
When he found out about the reward, he tried to claim it.
So is he in the right to claim it?
Oh,
He did find the nephew.
He did. But the court actually ruled against him, stating that you can't accept an offer you didn't know existed at the time you performed the act.
Hmm.
Acceptance requires awareness of the offer and the intention to accept it.
That's interesting. So you can't just stumble upon a reward and claim it if you didn't know it was out there.
Exactly, yeah.
It's all about the knowledge and intention behind the acceptance.
Exactly. And these cases might seem like, legal trivia.
Yeah.
But they actually set important precedents.
Right.
That shape how we understand offer and acceptance in contract law, even today.
Okay, I'm starting to see how these seemingly simple concepts can have all sorts of fascinating complexities.
Yeah.
What about those different types of contracts, right?
Okay.
The guide mentions void, voidable, valid, contingent, and quasi-contracts. They always seemed a bit, confusing to me.
It's true. There are different flavors of contracts, right?
Yeah.
And distinguishing between them is key, especially for exam scenarios.
Okay, let's take void and voidable contracts, for instance. What's the difference between those two?
Okay.
They seem pretty similar.
They do. They sound alike.
Yeah.
But there's a crucial distinction. A void contract is basically invalid from the get-go. It's like it never existed in the eyes of the law.
Okay.
A classic example would be a contract for something illegal, like hiring a hitman.
Right.
That contract is automatically void, regardless of what the parties intended.
Okay. So it's like the contract is inherently flawed and therefore unenforceable. What about voidable contracts?
So a voidable contract is one that is valid, but can be made void or unenforceable under certain circumstances. A common example is a contract signed under duress, meaning one party was coerced or forced into it.
So if someone held a gun to my head and made me sign a contract, that would be voidable.
Exactly. The contract exists, but the party that was forced into it has the option to make it void.
Okay, I think I'm starting to see the difference. Void contracts are inherently flawed.
Yes.
While voidable contracts are valid unless challenged by one of the parties.
Yeah, exactly.
But what about valid contracts? That seems self-explanatory.
You're right. Valid contracts are the ones that meet all the essential requirements. The building blocks offer acceptance, consideration, and so on.
Right.
They are legally enforceable and binding on both parties.
So a valid contract is the gold standard. Yeah. The ideal scenario where everything is in order.
Exactly.
And then there are contingent contracts, which sound a bit more, contingent on something happening.
Exactly. A contingent contract is one where the performance of the obligations is dependent on a specific event happening or not happening. For example, you might agree to buy a house contingent on securing a mortgage. If you don't get the loan, the contract becomes void.
So it's like a contract with a built-in if-then clause.
Exactly, yeah.
And finally, we have quasi-contracts, which sound a bit mysterious.
Yeah.
What are those all about?
So quasi-contracts, they're not technically contracts in the traditional sense. But they're legal obligations created by the court to prevent one party from unjustly benefiting at the expense of another. Think of it as a remedy to correct an unfair situation where there's no existing contract.
So it's like the court steps in and says, hey, even though there's no formal agreement here, you can't just take advantage of this situation.
Exactly.
Can you give me an example?
Yeah, imagine a scenario where a shopkeeper accidentally delivers goods to the wrong address. And the recipient, knowing it's a mistake, keeps the goods without paying. The court can create a quasi-contract obligating the recipient to pay for the goods that they received, even though there was no actual contract of sale between them.
So it's like the law steps in to create a sense of fairness, even in situations where a formal contract doesn't exist.
Exactly.
That's pretty cool.
It's a reminder that contract law is not just about rigid rules. It's also about principles of justice and equity.
Okay.
And speaking of ensuring fairness, let's dive into another crucial element of contract law.
Okay.
The concept of free consent.
Free consent?
Yeah.
That sounds pretty important.
It is.
After all, like a contract shouldn't be based on coercion or trickery, right?
That's absolutely right. For a contract to be valid, both parties must enter into it freely and voluntarily. Their consent can't be obtained through things like coercion, undue influence, fraud, misrepresentation, or mistake.
Right.
These factors can vitiate or invalidate consent, making the contract voidable.
So it's like if someone's like twisting your arm or feeding you false information to get you to sign, that's not a genuine agreement.
Exactly.
And the guide has this great tip about using a table.
Oh, that's great. Yeah.
To compare and contrast fraud, misrepresentation, and undue influence.
Yes, that's a great way to visualize. Right.
The distinctions between these concepts. They all involve some degree of like deception or pressure, but the specific elements and legal consequences differ.
So let's break those down. What exactly constitutes fraud in the legal context?
Okay, so fraud involves intentional deception with the aim of inducing the other party to enter into the contract. A classic example is selling a car, claiming it has low mileage when you know you tampered with the odometer.
Right.
That's deliberate misrepresentation to gain an unfair advantage.
So it's about intentionally lying to get someone to agree to something.
Yeah.
What about misrepresentation? Is that different?
Misrepresentation might involve a false statement, but the key difference is the intent. It could be an innocent misstatement or a negligent one, but without the deliberate aim to deceive. Like if someone's selling a car genuinely believes it's a certain model year based on faulty information, even if it's not.
Exactly. They might be misrepresenting facts, but without the intent to defraud. However, it's important to note that even innocent misrepresentation can make a contract voidable.
Okay, so fraud is a deliberate lie, while misrepresentation could be an honest mistake.
Yes.
But both can affect the contract's validity.
Exactly.
And what about undue influence? That sounds pretty intense.
Undue influence is about exploiting a position of power or trust to pressure someone into a contract that might not be in their best interest. Think about a manipulative family member or a trusted advisor taking advantage of someone vulnerable.
That's a tricky one. How do you determine if it's genuine influence versus like crosses the line into undue influence?
Well, the key is to look for an unequal power dynamic and whether that power was used to unfairly sway the other party's decision. The court would look at the nature of the relationship, the psychological state of the party who was influenced, and the overall fairness of the transaction.
Okay, so it's not just about like signing on the dotted line. It's about the circumstances and intentions behind the agreement.
Exactly. And to illustrate how these concepts play out in legal proceedings, let's look at the case of Dairy v. Peak.
All right, bring on the case study. What happened in Dairy v. Peak?
In this case, a tramway company issued a prospectus claiming they had the right to use steam power for their trams. The plaintiff, relying on this statement, bought shares in the company. However, the company was later denied permission to use steam power, causing the plaintiff to lose money.
So the company's claim was false, and the investor lost money.
Yes.
Seems like a clear-cut case of fraud.
Right. Not so fast.
The court ruled that although the company's statement was false, they didn't make it with the intention to deceive. Really?
They genuinely believed they would get permission for steam power.
So even though the statement was false and caused harm, the lack of intent meant it wasn't considered fraudulent misrepresentation.
Exactly.
That's a pretty fine line.
It is. It highlights how proving intent is crucial in fraud cases. It also reinforces the need for due diligence, right? Before entering into contracts, especially those involving significant investment.
Okay. So free consent is clearly like a cornerstone
it is.
Of contract law. And understanding these different types of vitiating factors, like fraud, misrepresentation, and undue influence, is crucial.
Absolutely. It's all about making sure the agreement is genuine, and not tainted by any shady practices.
Right.
And that brings us to another essential element.
Okay.
Consideration.
Consideration.
Yeah.
I have a feeling this is one of those like legal terms that sounds simple, but has a lot more to it than meets the eye.
You're right. It's one of the most fundamental concepts in contract law. In simple terms, consideration is the something for something element of a contract. It's the value that each party brings to the table. In India, this principle is outlined in Section 2 of the Indian Contract Act.
So it's like a trade-off.
Yes.
You give something, and I give something in return.
Precisely. It's a mutual exchange of value.
Okay.
Without consideration, you're essentially dealing with a gift, which doesn't hold the same legal weight as a contract.
Okay, that makes sense. Like if I promise to give you my car for free, that's a gift.
Yeah.
But if we agree that I'll sell you my car for a certain amount of money, that's a contract.
Yes.
Because there's an exchange of value.
Exactly. The car is the consideration from your side.
Right.
And the money is the consideration from the buyer's side.
But wait, I've heard that sometimes you don't need consideration for a contract to be valid. How does that work? It seems like if consideration is so important, there shouldn't be any exceptions, right?
You've hit on a fascinating point.
Yeah.
While consideration is generally required for a valid contract, the law does recognize certain exceptions.
Okay.
These are specific situations where an agreement can be binding, even without traditional consideration.
Okay, so it's not like a total free-for-all.
Yeah.
But there are some specific loopholes built into the system. What kind of situations are we talking about here?
Well, one exception is agreements based on natural love and affection.
Okay.
For example, a parent gifting property to their child out of love and affection doesn't require formal consideration for the agreement to be legally valid.
So family love trumps legal technicalities in those cases.
Exactly.
What other exceptions are there?
Another exception is a promise to compensate someone for a past voluntary act. Let's say you voluntarily save someone's life, and later they promise you a reward out of gratitude. This promise, though made without prior consideration, is enforceable by law.
Interesting. So even if you didn't agree to a reward beforehand, doing a good deed can still earn you some legal recognition.
Exactly.
Are there any more exceptions?
Yes. One more important exception is the promise to pay a time-barred debt. A time-barred debt is one where the legal time limit for pursuing legal action has passed. However, if the debtor makes a fresh promise to pay the debt, this promise is considered binding, even though the original consideration is no longer enforceable.
So even if time has technically run out on a debt, a renewed promise can revive it. That's good to know.
Yeah.
But how am I supposed to remember all these exceptions, like a legal maze?
Don't worry. The guide suggests using a mnemonic device. You could use the acronym NCLAT to represent natural love and affection, compensation for voluntary acts, and time-barred debts.
NCLA.
Yeah.
Okay. That's a clever way to keep those exceptions straight.
Yeah.
It's like a cheat code for contract law.
Exactly. And to help you see these exceptions in action, the guide references a case, Janaya v. Ramaya.
Okay. Case studies are always a good way to, like, connect the dots between theory and reality.
Yes.
What's the story behind Janaya v. Ramaya?
So Janaya v. Ramaya illustrates the exception of natural love and affection. In this case, an elderly woman gifted her property to her daughter, who was caring for her. Later, the woman tried to take back the gift, arguing lack of consideration.
So she was basically saying, hey, you didn't give me anything in return for the property, so it's not a valid contract.
Exactly.
Wow.
But the court saw it differently. They upheld the gift because it was given out of natural love and affection.
Which they recognized as sufficient consideration in this context.
So taking care of your elderly mom can actually count as legal consideration.
It can.
That's heartwarming and legally sound.
It is. It demonstrates that even without a formal exchange of goods or services, certain relationships and motivations can create legally binding agreements.
Okay, I'm starting to see how this whole consideration thing is a lot more nuanced than it seems at first glance.
It is.
There are rules, but then there are exceptions to those rules. It's like a legal dance.
It is, and that's what makes contract law so fascinating. It's a constantly evolving field, right, that tries to balance clear rules with the complexities of human interactions.
Speaking of evolving, let's talk about how contracts come to an end.
Okay, yeah.
They don't last forever, right?
Oh, no.
So what are the different ways a contract can say bye-bye? Well, the most straightforward way is through performance.
Okay.
This simply means that both parties fulfill their obligations as agreed upon in the contract.
Right.
Once everyone does what they promise, the contract naturally comes to an end.
Like if you hire someone to paint your house and they finish the job to your satisfaction, contract complete.
Exactly. Yeah.
But what happens when things go wrong, right?
Right.
What if one party doesn't fulfill their end of the bargain?
Then we enter the territory of breach. A breach occurs when one party fails to perform their obligations under the contract. Yeah. And when this happens, the innocent party has the right to seek remedies for the breach.
So it's like a legal timeout when someone breaks the rules of the game.
Exactly.
What kind of remedies are we talking about here?
Well, there are several options depending on the situation, right?
Okay.
We have damages, specific performance, and injunctions.
Okay.
Damages are monetary compensation awarded to the innocent party to cover their losses.
So if someone breaks a contract and it costs you money, damages can help you recover those losses.
Exactly.
Yeah. Okay. Specific performance.
Specific performance is a court order requiring the breaching party to fulfill their original obligations. Okay. It's like saying, you made a promise, now you have to deliver.
So it's not just about getting money back. It's about actually, like, forcing the other party to do what they agreed to.
Yes, exactly.
In the first place. And what about injunctions? What are those?
An injunction is essentially a court order prohibiting a party from doing something that would breach the contract.
Right.
Think of it as a preventative measure.
Okay. So if someone is about to break a contract, an injunction can, like, stop them in their tracks.
Exactly, yeah.
It's like a legal cease and desist order.
Exactly. So we have damages for compensation, a specific performance for enforcement, and injunctions for prevention.
A whole legal toolbox for dealing with broken contracts. But wait, the guide mentions another way a contract can end, right?
Yes.
Impossibility.
Impossibility, yeah.
What's that all about?
So impossibility comes into play when unforeseen circumstances make it genuinely impossible for one or both parties to fulfill their contractual obligations. Think about, like, natural disasters, unexpected changes in law, or even the death of a party in a personal service contract.
So it's not about someone just being lazy or changing their mind. It's about a genuine obstacle that makes the contract, like, literally impossible to fulfill.
Exactly. And the key here is these events must be unforeseeable and occur after the contract was formed.
Like if you rented a venue for an event, but then the venue was destroyed in a fire.
Perfect example. No one's at fault. But the contract becomes impossible to perform due to the unforeseen event. And there's a specific legal doctrine that applies to these situations. The doctrine of frustration.
Doctrine of frustration. It sounds like something you'd learn in, like, a psychology class, not a contract law lecture.
Well, you're not far off.
Okay.
This doctrine, which is enshrined in Section 56 of the Indian Contract Act, basically says that when an unforeseen event makes a contract fundamentally different from what the parties originally intended, the contract is frustrated and can be discharged.
So it's like the foundation of the agreement has crumbled, making it meaningless to continue.
Exactly. And the guide uses a classic case to illustrate this. Taylor v. Caldwell.
All right, hit me with another case study. What happened in Taylor v. Caldwell?
In this case, the defendant agreed to rent out a music hall for a series of concerts. But before the first concert, the hall burned down.
Oh, no. So what happened? Was the concert organizer just, like, stuck with a contract for a non-existent music hall?
Well, the court ruled in favor of the concert organizer, saying that the contract was frustrated because the music hall, the very subject matter of the agreement, was no longer in existence. It would be impossible to hold concerts in a pile of ashes.
Makes sense. So sometimes life throws you a curveball.
Yeah.
And the law recognizes that contracts can't always survive these unforeseen circumstances. But what about those situations where a contract is breached? Right. Let's delve deeper into the different types of breaches and their legal implications.
Yeah, you're right. Not all breaches are created equal. Understanding the nuances is crucial for navigating those exam scenarios.
So what are the different, flavors of breach?
The two main types are actual breach and anticipatory breach.
Okay. Actual breach seems pretty self-explanatory. Someone just, straight up breaks their promise.
Exactly.
What about anticipatory breach?
Okay.
That sounds a bit more complex.
Anticipatory breach occurs when one party clearly indicates their intention to not perform their contractual obligations even before the performance is due.
Right.
It's like giving you a heads up that they're going to break the contract.
So it's like a preemptive strike on the contract.
Exactly. Think of it like this. You've hired a band for your wedding. And a month before the big day, they tell you they can't make it.
That's a nightmare scenario.
It is.
But legally speaking, what's the difference between them canceling a month before versus just not showing up on the wedding day?
In both cases, they've breached the contract.
Right.
But with anticipatory breach, you have the option to terminate the contract immediately and seek remedies right away rather than waiting for the actual breach to occur.
So it's like getting a head start on the legal process.
Exactly, yeah.
Yeah.
It gives you more time to find a replacement band, for example, or mitigate your losses in other ways.
Okay, that makes sense. So even though the actual breach hasn't happened yet, the intention to breach is enough to trigger legal consequences.
Absolutely. It reinforces the importance of taking contractual obligations seriously and highlights the different ways breaches can play out.
And speaking of consequences, let's unpack those remedies for a breach contract. We touched on damages, specific performance, and injunctions earlier, but let's dive a bit deeper, especially into the different types of damages.
You're right. It's not a one-size-fits-all situation.
Yeah.
Understanding those different types of damages is key for understanding the nuances of contract law.
Let's start with ordinary damages.
Okay.
What are those all about?
Ordinary damages, also known as general damages, are meant to compensate the innocent party for the direct and foreseeable losses they suffered because of the breach. It's all about putting them back in the position they would have been in if the contract had been fulfilled as promised.
Okay. So if I agreed to buy a rare comic book from you for a certain price and you back out of the deal, I could claim ordinary damages to cover the difference if I have to buy that same comic book from someone else at a higher price.
That's a great example. Ordinary damages aim to cover the actual financial loss directly caused by the breach.
Okay. So it's about making the innocent party whole again.
Exactly.
What about special damages?
Okay.
How are those different?
Special damages or consequential damages
go beyond the immediate loss. They cover indirect losses that flow from the breach but weren't directly caused by it.
Okay, so it's like a ripple effect.
Exactly. But here's the key. These losses must have been reasonably foreseeable at the time the contract was made.
So it's not just about any random consequence. It's about those consequences that a reasonable person could have anticipated given the nature of the contract.
Precisely. And there's a famous case that illustrates this concept perfectly. Hadley v. Baxendale.
Okay, I'm ready for another legal drama. Tell me about Hadley v. Baxendale. What went down?
In this case, a mill owner hired a carrier to transport a broken crankshaft for repair. The carrier delayed the delivery, causing the mill to shut down for longer than expected. The mill owner sued for lost profits. So the delayed delivery caused the mill to lose money. Seems straightforward enough.
Yeah.
But there's a twist, right?
There is, yeah.
Okay.
The court ruled that the carrier could only be held liable for those damages that were reasonably foreseeable at the time they made the contract.
Okay.
Since the carrier didn't know the mill would be completely shut down without the crankshaft,
Right.
they weren't liable for the lost profits.
Wow.
Yeah.
That's a subtle but important distinction.
Yeah.
So even though the delayed delivery caused the mill owner to lose money, the carrier couldn't have reasonably anticipated those specific losses.
Right.
And therefore wasn't responsible for them.
Exactly. It underscores the importance of clear communication and making sure both parties are aware of the potential consequences when entering into a contract.
So, lesson learned. If there are specific circumstances that could lead to extra losses in case of a breach, make sure to spell them out clearly in the contract.
Absolutely. Clarity and foreseeability are key.
Okay, so we've got ordinary damages for like direct losses, special damages for foreseeable indirect losses.
Yeah.
What other types of damages are out there?
We also have nominal damages, exemplary damages, and liquidated damages.
Okay, lay those on me. What's the deal with nominal damages?
Nominal damages are a bit of a symbolic gesture.
Okay.
They're awarded when there's technically a breach.
Okay.
But the innocent party hasn't really suffered any actual loss.
So it's like a slap on the wrist for breaking the contract even if no real harm was done?
Precisely. It's a way for the court to acknowledge that a breach occurred.
Right.
Even if it didn't have major financial repercussions.
Okay. What about exemplary damages?
Okay.
Those sound a bit more serious.
Exemplary damages are all about punishment.
Okay.
They're meant to deter the breaching party from engaging in similar conduct in the future.
Right.
They're not common in contract law, but they might be awarded in extreme cases where the breach was particularly egregious, involving fraud or malicious intent.
So it's like saying, you really messed up.
Yeah.
And we're making an example out of you to discourage others from doing the same.
Exactly.
Okay.
It's about sending a message.
Right.
And finally, we have liquidated damages.
Liquidated damages?
Yeah.
What are those?
Liquidated damages are a fixed sum that the parties agree upon in advance to be paid in the event of a breach.
Okay.
It's like a predetermined penalty clause written into the contract itself.
Ah, so it's like saying, if you break this promise, you'll automatically owe this specific amount of money.
Exactly.
It eliminates the guesswork.
Yes. It provides clarity
and
prevents future disputes over how much should be paid in case of a breach.
That's smart. It's like a legal insurance policy against potential breaches.
Exactly.
But I imagine there are rules about how those liquidated damages are determined, right? It can't just be any random number pulled out of thin air.
You're right. The key is that the predetermined amount must be a genuine pre-estimate of the potential loss, not an arbitrary penalty designed to punish the breaching party.
Okay. So it's about fairness and reasonable expectations, even when dealing with potential breaches.
Exactly. Contract law is all about balancing rights and obligations and remedies, in a way that promotes fairness and predictability.
All right. We've covered a lot of ground here on damages. Ordinary, special, nominal, exemplary, and liquidated.
We have.
It's a whole spectrum of legal options for dealing with those contractual curveballs.
It is. And understanding how these damages work is key to truly grasping the intricacies of contract law.
Well, all this legal terminology can feel a bit overwhelming, especially when you're staring down those daunting exam questions.
Yeah.
Is there a way to make it all click? Some kind of secret weapon for tackling those case-based scenarios?
You're in luck.
Okay.
The guide introduces a powerful tool for just that.
Okay.
The IRS method.
IRA.
Yes.
Is that some kind of legal acronym?
It is.
Okay.
IRA stands for Issue, Rule, Application, Conclusion.
Okay.
It's a structured approach for analyzing legal problems and crafting well-reasoned answers.
Okay. So it's like a step-by-step framework for legal problem solving. Break it down for me. I'm all about making complex things simpler.
I like that. Okay. So the first step. Issue involves pinpointing the key legal question presented by the case.
Okay.
Then rule
Yeah.
requires you to state the relevant legal principles or rules that apply to that issue.
So define the problem.
Yes.
And then lay out the relevant legal groundwork. Makes sense so far. What about the next steps?
Application is where you connect the dots.
Okay.
You take those identified rules and apply them to the specific facts of the case.
Right.
Finally, conclusion is where you draw a clear and concise answer to the legal question based on your analysis.
So identify the problem, lay out the rules, apply the rules to the facts, and then draw a conclusion.
Exactly.
IRC.
Yeah.
Sounds like a pretty solid strategy.
It is. It's a logical approach that helps you organize your thoughts, right?
Yeah.
And build a persuasive legal argument.
Okay.
And the best part is the guide provides an example question to illustrate how to use IRC in action.
Perfect. Let's try it out. Imagine I'm a student staring down this question. A, promises to sell a car to B for RSE.
Yeah.
5 lakhs, but later refuses. Advise B.
All right.
Help. Where do I even begin?
Don't panic.
Okay.
We're going to activate IRAC.
Okay.
First, what's the key legal issue here?
Well, A broke their promise to B, so I guess the issue is breach of contract.
Exactly. Now, what's the relevant legal rule that applies to breach of contract?
I vaguely remember something about Section 73 of the Indian Contract Act dealing with damages for breach.
Yeah.
Am I on the right track?
You are. Section 73 states that the party who suffers from a breach is entitled to compensation for any loss or damage caused to them. Now, how do we apply this rule to our specific case?
Okay. A broke their promise to sell the car.
Yeah.
Which means B suffered a loss, right?
Yes.
So can B claim compensation from A?
Yes.
Under Section 73?
Precisely.
Oh.
A refused to fulfill their contractual obligation.
Yeah.
So B is entitled to compensation for the breach.
Wow. IRAC is making this much clearer. It's like having a roadmap for, like, legal reasoning.
Yeah, exactly.
What's our final conclusion?
Our conclusion is that B can seek damages for breach of contract from A.
Right.
By breaking down the problem into these 4 steps, we've analyzed the issue, identified the relevant rule, applied it to the facts, and reached a clear and well-supported conclusion.
IRA is a game changer. It's like having a legal GPS.
It is.
To navigate through those tricky exam questions.
It is. It's a valuable tool for anyone wanting to understand and apply legal principles in a structured way.
Okay. And this guide is like packed with these kinds of tips, right?
It is.
It's like a treasure chest for contract law success.
Absolutely.
Speaking of those tips, let's recap some of the key takeaways from the guide, especially for those of us facing, exams.
Absolutely. One of the best things about this guide is that it doesn't just throw a bunch of legal theory at you.
Right.
It provides practical strategies to help you actually remember.
And apply this stuff.
I love that. What are some of the standout strategies from the guide?
Well, they emphasize the importance of using flashcards, for those all-important sections in case laws. It's a simple but effective way to drill those key concepts into your memory.
Flashcards are my go-to. They're like portable brain snacks.
I like that.
For legal knowledge. What else does the guide recommend?
They also highlight the importance of practice. Yeah. It's not enough to just passively read about contract law.
Yeah.
You need to actively engage with the material.
Right.
And one of the best ways to do that is through answer writing.
So it's not just about like memorizing definitions. It's about actually applying those concepts to like real-world scenarios.
Exactly. And speaking of real-world scenarios, the guide stresses the importance of connecting legal concepts to everyday examples.
Right.
It helps make the abstract concrete and relatable. That's so true. It's like once you see how contract law plays out in your own life, it suddenly becomes much more interesting and memorable.
Exactly.
It's not just some like dusty old legal textbook anymore,
Exactly. And beyond these specific techniques, the guide emphasizes, good old-fashioned study habits.
Yeah.
Staying organized, revising regularly, and familiarizing yourself with past exam papers.
Those are like the foundations of success in any subject, but they're like especially crucial in contract law,
Right.
where so many concepts are like interconnected.
Absolutely. Consistent effort and a strategic approach will take you a long way in mastering this fascinating field.
Okay, so we've got our like steady game plan sorted.
We do.
But before we wrap up this deep dive,
Okay.
there's one more concept
Okay.
I'm curious about.
Okay.
The guide mentioned something called privity of contract.
Okay.
What's that all about?
Privity of contract is a key principle that determines who has the right to enforce a contract.
Okay.
Think of it as a legal VIP club for contract enforcement.
Okay, so who gets to be a member of this exclusive club?
So privity of contract means that only the parties involved in the contract, those who provided consideration, have the right to sue or be sued on it.
Okay.
It's about keeping the legal boundaries clear and ensuring that only those who made the agreement are bound by it.
So if I'm like not a party to the contract, I can't just like swoop in and try to like claim benefits or enforce its terms, even if it affects me in some way.
Exactly.
Well, it's like a legal hands-off to outsiders.
Exactly. A good example is a scenario where your friend orders a pizza but doesn't pay. The pizzeria can't come after you for the money just because you happen to eat a slice. You weren't part of the contract.
Okay, I see the logic there. It's about keeping things fair and predictable.
Exactly,
But are there ever, like, any exceptions to this privity rule?
There are. The law is full of exceptions. And over time, courts have recognized that strict adherence to the privity rule can sometimes lead to unfair outcomes. So they've developed certain exceptions to ensure that justice prevails.
Okay, so it's not like a completely rigid rule. There's room for flexibility when circumstances require it.
Exactly,
What are some of the key exceptions to the privity rule?
Well, one important exception is the concept of agency.
Agency. So like spies and secret missions.
Maybe.
Is contract law about to get a lot more exciting?
Maybe not as action-packed as a spy thriller. But the concept of agency is indeed crucial in contract law. It involves one person, the agent, acting on behalf of another person, the principal, to enter into a contract with the third party.
So if I authorize someone to make a deal on my behalf, they become like my legal representative in that contract, even if I don't like directly sign it.
Exactly. A great example is real estate transactions, right? When you hire a real estate agent, you're essentially granting them the authority to negotiate and sign contracts on your behalf.
So the real estate agent is like my contractual wingman making deals in my name.
I like that.
But how does that like relate to the privity of contract?
So in this scenario, even though you, the principal, might not have physically signed the final contract with the buyer or seller, you are still bound by its terms because your agent was acting on your behalf.
So even though I'm like behind the scenes, I'm still like a key player in the contract thanks to my trusty agent. What other exceptions to privity are there?
Another significant exception is the concept of beneficiary, which often pops up in like trusts and insurance contracts. A beneficiary is a third party who is specifically named in the contract as someone who is intended to receive benefits, even though they weren't directly involved in creating the contract.
So if someone sets up like a trust fund for their child and names the child as the beneficiary, the child has the right to like enforce the terms of that trust, even though they weren't part of the original agreement.
Exactly. The beneficiary, in this case the child, has legal standing to sue the trustee if they fail to administer the trust properly.
Wow.
So the child's rights are protected even though they weren't a party to the initial contract.
Okay, so beneficiaries have some like serious legal clout.
They do.
Even if they're not directly at the negotiating table. It's like they're the designated VIPs of the contract, entitled to all the benefits without having to like deal with the nitty-gritty of the agreement.
That's a great way to put it. These exceptions to privity demonstrate that contract law is not always rigid, right? It has a heart. It adapts to situations where fairness and justice demand flexibility.
It's reassuring to know that the law takes those nuances into account. So we've got agency and beneficiary as two key exceptions to the privity of contract rule. Are there any others?
Yes, there are a few other exceptions, such as acknowledgments of liability and certain statutory provisions that allow third parties to enforce contracts in specific circumstances.
Okay, so it's not a hard and fast rule, right?
Right.
There are situations where the circle of enforcement can expand beyond the original parties to the contract.
Right.
But for the most part, it's important to remember that only those who are directly involved in the agreement, those with privity, have the legal standing to enforce it.
Exactly. Privity of contract is a foundational principle that helps maintain order and predictability in contractual relationships.
And speaking of maintaining order, let's move on to another important aspect of contract law.
All right.
The concepts of assignment and novation.
Okay.
These deal with transferring rights and obligations under a contract to a third party.
You're right. These concepts allow for some, strategic maneuvering within the contractual landscape.
Okay.
Let's start with assignment.
Okay. What's an assignment all about?
An assignment involves transferring contractual rights from one party to another.
Okay.
The original party, called the assignor, assigns their rights to a third party, the assignee.
So it's like passing the torch of your contractual rights to someone else.
Exactly. Think of it like this. If you're owed money by someone, you can assign that right to receive the money to a third party, like a debt collection agency.
Right.
The debtor still has to pay.
Yeah.
But now they owe the money to the agency, not you.
So the debtor's obligation remains the same, but the recipient of the benefit changes hands.
Yeah.
Okay. I think I'm following.
Okay.
What about novation?
Okay.
How is that different from an assignment?
Novation is a bit more complex.
Okay.
It's not just about transferring rights.
Right.
It's about substituting one party in the contract with an entirely new party.
So it's like swapping out one of the players in the game.
Exactly. And for novation to be valid, all the parties involved, the original parties and the new party, have to agree to the change.
Okay. So it's not like a unilateral move.
No.
Everyone has to be on board with the substitution. What are some common scenarios where novation happens?
One common scenario is when a business is sold. Existing contracts of the business might be novated to the new owner. Meaning the new owner steps into the shoes of the old owner in those contracts, taking over both the rights and obligations.
So it's a way to ensure continuity and prevent disruptions when ownership or responsibilities change hands.
Precisely. Novation helps make those transitions smoother and protects the interests of all parties involved.
Okay. So we've got assignments for transferring rights and novations for substituting parties.
Yeah.
It's like contract law has built-in mechanisms for adapting to changing circumstances.
Yeah.
But what about those contracts we encounter every day? Right. Those pre-written agreements that we rarely read but just click agree on.
Right.
The guide refers to these as standard form contracts.
You're talking about those ubiquitous online terms of service, mobile phone contracts, and all those other take it or leave it agreements, right?
Yeah.
That are so prevalent
they're everywhere
in our digital world.
But are they even legally valid if no one actually reads them?
They are.
Really?
Standard form contracts are legally valid.
Okay.
But they do raise important questions about fairness and transparency.
Yeah.
After all, they're often drafted by one party with little to no room for negotiation and can be filled with complex legal language that most people don't have the time or expertise to decipher.
It's like they're banking on the fact that most of us will just blindly click agree.
They are, yeah.
Without understanding what we're actually agreeing to. Does the law offer any, protection?
It does.
In these situations?
Courts have developed doctrines to protect consumers from unfair or unconscionable terms hidden within those dense pages of legalese.
Okay, so it's not like a legal Wild West where anything goes.
No.
What are some of those, legal safeguards that protect consumers from those, gotcha clauses buried in standard form contracts?
One important safeguard is the doctrine of unconscionability.
Okay.
This doctrine basically allows the court to refuse to enforce a term if it's so one-sided, oppressive, or unfair that it shocks the conscience of the court.
So it's like the court is saying, hey, this clause is just too outrageous. We're not going to let you use it to take advantage of someone, even if they technically agreed to it.
Exactly.
Yeah.
It acts as a safety net,
Right.
preventing companies from exploiting consumers with overly aggressive contract terms.
That's reassuring.
Right.
What other safeguards are there?
Another important principle is contra pro forentum.
Okay.
It's a fancy Latin phrase.
Latin phrases always make me nervous.
I know.
But break it down for me. What does contra pro forentum mean?
It essentially means that if there's any ambiguity or uncertainty in a contract term, you know, the court will interpret it against the party who drafted the contract.
Right.
It incentivizes companies to use clear and unambiguous language and avoid sneaky clauses that could be interpreted in multiple ways.
Ah, so it's like a legal penalty for sloppy drafting.
Exactly.
If you're going to write a contract, you better make sure it's crystal clear.
Yeah.
Or else the court might interpret it in a way that benefits the other party.
Exactly. It's a way to level the playing field, right?
Yeah.
And protect those who might not have the legal expertise to navigate through complex contractual language.
Okay, so even though those like standard form contracts can feel like a take it or leave it situation, there are legal principles in place.
There are,
to ensure fairness.
Yes.
It's a relief to know that the law has our backs.
It does.
So we've covered a ton of ground today.
We have.
From offer and acceptance to those tricky standard form contracts.
Yes.
But before we wrap things up, I wanted to touch on something that came up in the guide that really caught my attention.
Okay.
It talked about how contract law is constantly evolving, especially in our digital age.
It's true. As technology advances and our ways of interacting change, contract law has to adapt to keep pace.
Right.
Think about all the new ways we form agreements online through apps, websites, and even social media platforms.
Yeah. It's like the digital landscape is constantly creating new scenarios.
It is.
For contract law to grapple with. What are some of the biggest challenges facing contract law in this digital age?
One major challenge is ensuring that online agreements meet the same standards of validity and enforceability as traditional written contracts.
Right.
After all, just because you're clicking a button instead of signing a piece of paper doesn't mean the legal principles should be out the window.
That's a good point.
Yeah.
A click should have the same weight as a signature in the right context.
Yeah.
What else is tricky about applying contract law to the digital world?
Another challenge is dealing with the sheer volume and complexity of online agreements.
What?
Think about those lengthy terms of service that we're all guilty of scrolling through without reading.
Yes.
How do we ensure that consumers are truly informed and understand what they're agreeing to in these digital transactions?
It's like we're drowning in a sea of digital legalese.
Yeah.
Is there a way to make these online agreements more user-friendly and transparent?
Absolutely. There are ongoing efforts to develop standardized formats, simplified language, and even visual aids to make online contracts more accessible to the average person.
That would be a game changer. It's like translating legalese into plain English.
It is, yeah.
For the digital age. Are there any other areas where contract law is having to adapt to these new digital realities?
Another hot topic is jurisdiction.
Okay.
In the online world, it's not always clear which laws apply when parties are located in different countries.
That's true. It's a global marketplace.
Yeah.
But the legal landscape can be very localized. How does contract law handle these cross-border transactions?
There are international treaties and conventions that aim to harmonize contract law principles across different countries, but it's still a complex and evolving area.
It's like trying to fit a square peg into a round hole sometimes.
It can be, yeah.
But it's exciting to think about how contract law is rising to meet these challenges and shaping the future of digital commerce.
It is. It's a reminder that the law is not static, right?
Right.
It's a living system that constantly adapts to the changing realities of our world.
Well, I think we've given our listeners a lot to think about today. Contract law is clearly a fascinating and dynamic field, one that impacts all of us, whether we realize it or not.
Absolutely. From the coffee we buy to the agreements we make online, contract law is woven into the fabric of our daily lives.
Yeah.
And understanding its principles empowers us to navigate these interactions with confidence and clarity.
Well said. We hope this deep dive has demystified contract law.
Yeah.
And sparked a curiosity to learn more about this, like, vital area of law.
We've just scratched the surface, but hopefully this has given our listeners a solid foundation to build upon.
And remember, if you have any questions or want to share your own aha moments,
please do.
Feel free to connect with us on social media. We love hearing from our listeners.
Until next time, stay curious
and
keep exploring the fascinating world of contract law.
Happy contracting.